This is Robert J. Kolasa, estate planning attorney and CPA in Lake Forest, Illinois. Today's topic is custom drafted trusts. In my practice, I take great pride in providing custom drafted trusts for my clients, which take into account their specific situation, including family members, tax situations, creditor issues, and a whole variety of other situations which affect the terms of how their estate planning documents are drafted. Here are some common scenarios involving custom drafted trusts. Delayed distributions based on age or educational achievements. If you have minor children, wouldn't it be a mistake to provide that they get their inheritance at age 18? That's the minimum age a child can inherit wealth under Illinois and most states. No, you wouldn't want to do that. You would want to stretch it out over an interval of time, because sudden access to wealth could act as a disincentive for your children to become productive members of society. Instead of giving them all the wealth at age 18, why not stretch it out? A third at age 21, 25, 30. Maybe a third at 25, 30, 35. Stretch out in the inheritance over intervals. So if they blow the first chunk, they'll have something left over at the end. Or how about this? If you have adult children, give them a third at your death, a third 5 years later, and a third 10 years later. Or maybe the age should be 60 or 65. You can decide what that would be. Whatever you have a college student who may not get his or her degree through lack of effort, why not key the inheritance be based upon the child attaining his or her degree? Don't you think that would be an incentive? The point is, there's a lot of flexibility and creativity we can adopt in setting the trust terms when your children will inherit your trust assets. Think about it. It makes sense. Drug or alcohol impaired beneficiaries present special planning challenges. Of course, in such cases, it would be a mistake for such beneficiaries to receive their inheritances outright from you upon your death. Why? They'll blow the money, or perhaps kill themselves with such proceeds. In such cases, a trust can be set up, run by a trustee who will monitor the behavior of their children and reward them. If they're clean and they have good behavior by holding a job, distributions can be made to them. However, if they're on drugs, perhaps it would be better to make distributions to facilities or institutions for their benefits. These types of trusts can be drawn up carefully to protect the funds for your children and hopefully aid them in kicking their habit. Educational trusts for grandchildren. I love this area because I have college-age kids. I know how expensive it is to provide for a college education. If you're a grandparent, maybe, just maybe, consider devising at your death a portion of your estate for the college education of your grandchildren. I have a lot of experience in setting and drafting these trusts. Maybe you could set it up at death, or perhaps even a current trust during your lifetime for educational purposes. For wealthy taxpayers, did you know if you pay tuition directly to the university, it's gift tax free? What a great area. Invest in the future of your grandchildren. It's worth it. Planning for second marriages. Wow, what a tough area. If you remarry, typically you would want to provide for your second spouse. However, you would also want to provide for the children of your first marriage. How do you balance out these competing objectives? Often clients ignore this tension and they rely upon luck. Sometimes the surviving spouse gets all the assets. Sometimes the surviving spouse gets nothing. It's a very difficult situation. Many times it takes a lot of effort to develop these plans on a satisfactory basis. However, I do have experience doing this. Perhaps the spouse can have an income stream in a trust. So upon his or her death, such assets will go to the children of first marriage. Often, this will help the estate tax planning of both spouses. Again, this requires careful consideration, but I do have experience in developing plans for this type of clientele. Disabled child. What if you have a disabled child? How do you plan for his or her future? Upon your death, should you set up a trust for that child? Well, I'll tell you what, if you don't plan carefully, it could be a disaster. Such inheritance could prevent a child from obtaining or continuing governmental assistance. In such cases, we set up what are called supplemental needs trusts. Again, supplemental needs trusts are special trust vehicles in which a disabled child can inherit money, but importantly, not disqualify such child from governmental benefits. I have experience in this practice area.